Good afternoon. Our guest of honor, Senior Professor Dr. G.S. Bajpai, Honorable Vice-Chancellor, National Law University, Delhi. Honorable Vice-Chancellor of Dr. B.R. Ambedkar, National Law University, Sonipat, Professor Dr. Devinder Singh. And our worthy Registrar, Professor Dr. Ashutosh Mishra. Distinguished guest, esteemed panelists, respected faculty members, dear delegates, research scholars, students, and participants for joining us here in person and online. It is my privilege today to introduce our distinguished guest of honor, Professor Dr. G.S. Bajpai. Honorable Vice-Chancellor of National Law University, Delhi, is among India's most eminent legal academicians and public intellectuals. A distinguished scholar in criminal justice administration, criminology, constitutional governance, and human rights, Professor Bajpai has authored and edited numerous books and research publications that continue to shape contemporary legal scholarship. His contributions toward legal education, policy research, victimology, and criminal justice reforms have earned him national and international recognition. As Vice-Chancellor of the National Law University, Delhi, he has consistently championed excellence in legal education, interdisciplinary research, and institutional innovation while nurturing a generation of socially conscious legal professionals. Sir, your presence today immensely enriches this conference, and we are deeply honored to welcome you. May we extend a warm welcome to Senior Professor Dr. G.S. Bajpai with a huge round of applause. I now request our Honorable Vice-Chancellor, Sir, Professor Devinder Singh, to kindly felicitate Senior Professor Dr. G.S. Bajpai. Thank you, sir. May I now request our Honorable Vice-Chancellor, Professor Devinder Singh, to kindly address the gathering.
Professor G.S. Bajpai, Honorable Vice-Chancellor, National Law University, Delhi, Chief Guest for today's function in the afternoon. We are grateful that despite his busy schedule, one of the most challenging tasks in the university is the recruitment, and Sir was busy in that. But we have taken the permission from Sir earlier that we are commemorating this 50 years of the dissenting judgment, and Sir's academic input was also there. So when we fixed the date and invited Sir, he was gracious enough, and today he is here with us. This is a valedictory cum panel discussion function, but Sir has its own limitation of time. Therefore, Sir will address us. So, as per schedule, Sir, you are welcome in the National Law University, Sonipat. We are prized as a neighbor by the geography itself, and will continue to learn from each other. This program may be the beginning, as we have started with this program, and in near future we would be collaborating for many things. One of the things which we can do at very ease from the administrative side, that is the exchange of students for many programs. So whenever there is a function in the NLUD, students are advised to look their website regularly, and whenever you find the program of your interest, then you can go. We are the neighbors, so we can grow together in the NCR region. I welcome also the other panelists, Chaturvedi ji, Pradeep ji, and Deepak ji from Prayagraj. We are all collaborators for this function, and we hope that as we have inaugurated the programs today, this is the beginning of the programs today, and I guess it will go up to 28th of February, when finally Justice Hansraj Khanna was superseded as a judge, not to become the Chief Justice of India. Till that date, we will continue our functions. In the other collaborating institutions, there would be functions. We will also organize more functions in our university, and in collaboration with other universities, maybe colleges or in other universities. So we will continue this. So finally, if we conclude it after 9-10 programs, that is our idea, that at least 9-10 programs should be there, and around 50 papers should be there, and that should be published to celebrate the dissent and celebrate the courage of Justice Hansraj Khanna. It would be a befitting tribute to a judge who can speak under the circumstances for which he spoke. So this session belongs to Bajpai sir and the panelists. So my duty is only to welcome the guests. So I extend a very warm welcome to everyone, to the faculty, to the student, and congratulate the organizing team that they have been working since a week, and today the result is shown that everything is going smoothly. Thank you very much, everyone.
Thank you, sir, for your warm welcome to everyone. May I now request Professor Bajpai to kindly grace the dais with his words.
Learned Vice-Chancellor of Dr. B.R. Ambedkar National Law University, Sonipat, Professor Devinder Kumar, Professor Ashutosh, the Registrar of the University, Dr. Chaturvedi on the dais, Professor Pradeep, and Dr. Deepak, and all the faculty members of this university, invited guests, dear students. This is my distinguished honor to be with you this afternoon for this very momentous occasion, and for which I stand here to congratulate the university and its leadership for thinking of organizing this event. This is not an ordinary event or a conference of any kind, because it is there to underline a very important moment of the constitutional history of this country. Because when we talk of the 50 years of constitutional dissent, in terms of revisiting the grand legacy of Honorable Justice H.R. Khanna, and that ADM Jabalpur movement of 1976 is a watershed in the constitutional history of this country for various reasons. I am particularly happy that the young students are sitting here, and I am of the view, if I had to count 3 important moments of the history which should always be there in your mind as a law student, one is this: And I can tell you with complete confidence that this particular issue that we are discussing today in terms of this conference, habeas corpus case, what we generally call, will revisit you and will come across you and will cross your path all the time during your entire journey of journey as a law student. And you will then realize probably the remarkable feature of this entire case and its impact for the subsequent jurisprudential insights in the country. And in that sense, I want to use my time to do two things. First, to examine how Justice H.R. Khanna dissent changed the way our courts reason about the fundamental rights. And second, to consider what his legacy did to dissent as a judicial practice. Whether disagreement from the bench is treated as legitimate and necessary or as something to be minimized. These two questions are in my mind while I stand before you. And I will begin with the 1976 movement. You all must remember these important journeys that the constitutional history has completed. So very well, still as a, we know that what happened in 75 into the early months of 1976, we are knowing that a lot of people were detained, political dissenters and all under Mishra, because of the Article 359, which received the assent of the president. And then the government has started, and there's a background that how Indira Gandhi lost his case before that in Allahabad, how his election was held to be legal, how the emergency was invoked. But what happened during the emergency was something that has actually the background for this particular case. Because when judgment was delivered, before that, a lot of people were arrested, as you all know. Shivkant Shukla was also one of them. I think 8 to 9 high courts had those cases. They were all appended together and brought to the Supreme Court 5-bench judge, that you all know. And then came the existence of this very important case where the judgment was delivered perhaps on 28th April of 1976. You have to remember this date. This date is as I have said, the watershed moment in the history of the constitutional history of this country. Now, if I take you to the important things, of course, when this case came, the key question was whether during the emergency, the fundamental rights of the people as enshrined in Article 14, Article 20, Article 21, specifically Article 21, whether they also remain suspended or the judicial remedy under 226 or 32 in High Court and Supreme Court remain. So this was a major question because people were arrested. So habeas corpus is a method of seeking the physical appearance of that person, and people went to the writ jurisdiction, and the Supreme Court had done well because the government of India, the Union government, appealed against all these orders. And then came this issue before the 5-bench consisting of Justice A.N. Justice Beg, Justice Chandrachud, Justice P.N. Bhagwati, and they said all four no. Four said no. No remedy exists if the Constitution is in suspension. That was the troubling, finding of the court. 4. Now, fifth one, Justice Khanna refused the premise itself. And he said, the right to life and liberty was not the creation of Article 21. He said people's right, life is so sacrosanct that it existed all the times, whether there is a constitution or no constitution. That is the state liability to protect the life of the people. But then came the issue that even in the absence of 21, the state has no power to deprive a person of life and liberty without the authority of law. This is what he said. The state cannot unmake what it never made. That was the observation came from the court. And what followed is well known for us. The fact remains, Justice Khanna was the senior most judge of the Supreme Court. And you all know those things, but I will straightway come to this debate because for a law student, it is not enough to simply know what is the source of both the arguments. I will take a couple of minutes, 2-3 minutes to tell you something which is not very expressly written, but then the premise that was being built by these 4 judges, when they say all the rights are the part of the Constitution, they flow from the Constitution, Article 21. And if Article 21 is no longer in existence or has been suspended through an act or through an order of the President, then the remedy against these rights is also not there. Now, this is one premise which you can say or which you can call in legal terms. This is called, extreme positivism. This is the extreme positivism. Positivism or positivist school relies on the statutory interpretation of the law. So statutory, on the count of statutory interpretation, 4 judges were correct. If you make a very strict interpretation, you will see that if Constitution is not, has been suspended, so Article 21 also remains suspended, then there is no question of right to life. There is no question of any judicial remedy. So you need to understand as a law student that if Justice Ray, Justice Wade, Justice Chanchur, Justice Bhagwati, they adopted a strict legal positivist interpretation of the constitutional framework, and they asserted Part 3 of the Constitution was the sole repository of the right to life and personal liberty. Consequently, they reasoned that Article 21 constituted the state's entire rule of law regarding personal freedom. Once the Presidential Order Article 359 suspended the enactment of Article 21, no pre-constitutional, natural or common law right to liberty survived. This was the key observation. And therefore, you need to understand as a law student that what is that positivism which these 4 judges were talking. That is the one position because of which these 4 judges have reached to this conclusion. The question, fellow law student, is that what is the source of the reasoning adopted by Justice H.R. Khanna? It is not enough to say that he dissented in favor of the detainees. Judges do not do anything off the cuff. They have to give a reasoned order. The reasoned order means they have to say what is the premise on which you are relying. Now, Justice Khanna rejected both the positivist premise and the executive deference of his colleague. Executive deference means they were saying now it is with the government. Justice Khanna rejected both the premise and grounding his analysis in three things actually, which you need to understand. Justice Khanna's premise flow from natural rights, common law, and human rights principles. So these three things have actually brought the whole, and he argued that right to life and personal liberty did not originate with the Constitution. He said, see, this is such a remarkable finding. He said, the people's liberty did not originate from Article 21. We all believe that Article 21 is the sole repository, that is fine. But originating position of this right is not located in Article 21. It merely codified. It said it merely codified already existing, rights, pre-constitutional right and human rights, and which inherently belongs to every individual in a civilized society. Whether constitution is there or not there, it is a presupposition of a kind in a governance system that the people will have these rights. So this is Khanna established that the rule of law is the absolute antithesis of arbitrariness. And then he reasoned while the presidential order releases the legislature from the constitutional restrictions of Article 21, it does not empower the executive to act without statutory legal authority. That is the whole thing that he said. For an executive action detrimental to life or liberty to be valid, it must possess the clear backing of validly enacted law. So without statutory authorization, an arrest is lawless act and the writ of habeas corpus remains available. This is beautiful reasoning that he is as an essential judicial mechanism. Now, the issue is, I will come to little, current things which we have to see, because how the fundamental rights have then been shaped subsequently, because Justice Khanna's, you will immediately see, I'm now turning to those two questions which I have raised very briefly in 5 minutes, I will say. I will not offer a catalogue of cases which have actually impacted by this particular decision, but I would certainly tell you about Article 21, what it became subsequently, and that is very important for you to understand. 2 years later, you will see in 78, Maneka Gandhi case came again. You cannot ignore Maneka Gandhi case. You have to study this case line by line. Don't study the summary, précis or abstract. Read this case. And you will come to know that the court in this case held that any procedure which takes away the life, liberty, must be fair, just, and reasonable. This golden triangle of 14, 21, and 20 has become a kind of departure point for all the cases subsequently with respect to the, people's liberty and freedom. And underlying premise is one that Justice Khanna had already put down. A right that does not come from the statute cannot be satisfied by the statute alone. This is the golden triangle of therefore 14, 19, and 21. The insistence that procedure itself must meet substantive standards of fairness and 20. Many people ask me these days, do you read newspaper? You know brigadier justice. What is that? But see, you are given an impression that there are 2 types of situation I would draw from this case, which we must you are a law student. Law particularly create two kinds of situation. One is we think, as because you are shown a picture by these kinds of actions, you read a lot of newspaper, that the law creates a liability. Every law creates a liability. You know what is the liability? So in every law you read that if you do not follow, this is the consequence, this is the penalty, this is the punishment, these are the consequences. That is called the liability which is inherent in the structure of the law. The second thing which you perhaps do not read as frequently as you should, and that would make what kind of a student you be. I call it, it is a right conferring aspect of law. Law confers certain rights also. Law creates liability, but law also creates certain rights and obligation on the part of executive. So please read now. So because of your ignorance, we are unable to ask those questions which pertain to the law. Like for instance, procedural law. Fair, just and reasonable is good enough to stand against any state or executive excess that you experience. Why the Allahabad High Court had to issue 7 guidelines against the illegal actions by the state. State thought the executive power can be carried out without any responsibility, but that is not the case. You have to have a reasonability clause. So that is one. Second, you need to understand that what kind of system you are actually aiming at. Justice Khanna had options actually, but he chose a difficult option. You know, what was the option before Justice Khanna? He was to be elevated as the Chief Justice of the country. But because of this judgment, obviously, he was ignored and Justice Wade was elevated. This is the price Justice Khanna paid for actually upholding the rule of law in the country. Now today, perhaps you may not be knowing Justice Wade, but you certainly remember Justice Khanna. That is the beauty. So history is very cruel. At the time, you may think that you can get away with the things, but history will come back to you. After 41 years in Puttaswamy, the constitutional mistake was amended because 41 years the judicial institutions live with what I call a kind of institutional guilt. We all have been through this institutional guilt. And what was surprising for me, in that bench, one of the judges who was the part of that bench was Justice Bhagwati. Justice Bhagwati is considered to be the champion of rights, human rights. But he was also there. So I am reminded of that scene of Mahabharata when, despite the presence of Bhishma and Dronacharya, injustice was made in the Dhrut Kira. वहां तो कहीं ना कहीं जब आप तटस्थ रहते हैं तो उसका भी आपको जयद्रथ को कविता में कहा गया है उसको समय देगा उसका आपको हिसाब. So that is the price. There is a beautiful book by Gurcharan Singh, Difficulty of Being Good. It's a beautiful book. You just read that book where you will be told about that there are occasions where you are inherently good, but sometimes you happen to take the side of something which is not fair. Problem is this, that person like Justice Bhagwati had occasion to, choose, and he made a wrong choice. And interesting part is that Justice Bhagwati actually publicly apologized also. Later stage, the history is very cruel. We should learn these things. And Justice Bhagwati, we all keep him on the top. He is the only judge who has not delivered any single death penalty in this country. He was dead against the, this kind of external laws. He was most pro-human rights judge. The PIL, the public interest litigation, was the gift that Justice Bhagwati came. But he was the part of that bench. He couldn't say no on that particular day. And that became, I think, the stature of Justice Bhagwati would have been much more higher. There's no doubt about it. But it happened. So I would say that you need to look at how these judgments have actually shaped. So today you have this opportunity to revisit the legacy. And last, I think we have a couple of minutes. Just remind me. So the issue is the doctrinal foundation of Justice Khanna has paved the way for many judgments to actually lay down this entire turf for a very pro-human rights stance later on. And the thing that you see these days, because we are now in a different age and era, dissent became a kind of important tool now in judicial discourse. You will see the dissent has, brought a lot of new insights and new jurisprudence later on. If you remember in Sabrimala, Justice Indu Malhotra's dissent, she being a woman,